Related quorum in the standing orders of the Senate. Standing order number 58. The Senator for Marsabit County, Senator Mohammed Shute, is set to make a statement pursuant to standing orders number 58 regarding the false report of his arrest by the Ethics and Anti-Corruption Commission, EACC, under standing orders number 53, subsection 1. The Senator for Nyandarua County, Senator John Mithu, will be seeking a statement from the Standing Committee on Matters Roads, Transportation and Housing regarding the status of insurance cover for motor vehicles belonging to the county government of Nyandarua. The Senator for Kisii County, Senator Richard Onyonka, will this afternoon also be seeking a statement from the Standing Committee on Matters Land, Environment and Natural Resources regarding the exploration of minerals in Kenya. And finally, under Standing Orders number 53, subsection 1, the Senator for Marsabit County will be seeking a statement from the Standing Committee on Matters Land, Environment and Natural Resources regarding the operations of Northern Rangelands Trust in Marsabit County. The National Assembly Construction Authority Amendment Bill, Senate Bills number 59 of the year 2022, is a bill lined up for consideration this afternoon. I gather that the quorum has been attained this afternoon. So let me hand you over for this live broadcast. And this is in the great partnership with the parliamentary.
Then we proceed with the communication. We have a good, we are very good at it. So do we proceed? Yes. Order, honorable senators, kindly take your seats. We do have quorum now, so we proceed with the afternoon's business. Clerk, you may proceed to call the first order.
Order number 1, administration of oath. Order number 2, communication from the chair.
Senator Robert, take your seat, please. Now, honorable senators have a communication to make concerning the motion by the Select Committee on Delegated Legislation on the consideration of the Valuers, Forms and Fees Amendment Rules 2024, Legal Notice number 69 of 2024, the Survey Amendment Regulations 2024, Legal Notice number 71 of 2024, and the Land Adjudication Amendment Regulations 2024, Legal Notice number 76 of 2024. Honorable senators, we recall that at a sitting of the Senate held on Thursday, the 2nd of May 2024, the following regulations were tabled by the Senate Majority Leader. 1. The Valuers, Forms and Fees Amendment Rules, Legal Notice number 69 of 2024. 2. The Survey Amendment Regulations, Legal Notice number 71 of 2024. And 3, the Land Adjudication Amendment Regulations, Legal Notice number 76 of 2024. In accordance with Section 12 of the Statutory Instruments Act, the regulations were referred to the Select Committee on Delegated Legislation. Section 15.2 of the Statutory Instruments Act states as follows: where the committee does not make the report within 28 days, sitting days, of the date of referral of the statutory instruments by the committee or other period as the House may, by resolution approve, the statutory instrument shall be deemed to have fully met. The committee was required to review and scrutinize the regulations within a period of 28 sitting days. The time allowed for the committee to consider regulations was scheduled to lapse on Tuesday, the 30th of July, 2024, which was yesterday. Honorable Senators, you will recall that at a sitting of the Senate held yesterday, Tuesday, the 30th of June, 2024, pursuant to Section 15.3 of the Statutory Instruments Act, the chairperson of the Select Committee on Delegated Legislation gave a notice of motion seeking an extension of time for consideration of the aforementioned regulations for a further period of 21 days in order to enable the committee to conclusively consider them. The substantive motion for debate and approval was scheduled in the order paper for Tuesday, 30th of July, 2024 at order number 28. The Speaker reorganized the sequence of business pursuant to Standing Order 45-2 after the divisions to give this motion priority. However, at the conclusion of the debate and in the absence of the requisite quorum for the question to be put, the mover requested for the question to be deferred to a later date pursuant to Standing Order 66-3. Now, Honorable Senators, Section 15.1 of the Statutory Instruments Act requires a committee to which a statutory instrument has been referred to table a report to Parliament containing only a resolution that the statutory instrument that stands permanently referred to the committee be revoked. As earlier highlighted, Section 15.2 states that in the event that the committee does not table a report within 21 days or such other period as the House may resolve, the statutory instrument shall be deemed to have been approved. The motion before the Senate was seeking an extension for consideration of the regulations, and the failure to approve the motion during the sitting of the Senate held yesterday, Tuesday, 30th of July, 2024, takes us back to the provisions of Section 15.2 of the Statutory Instruments Act. Honorable Senators, this being the case, the Values, Forms and Fees Amendment Rules, Legal Notice number 69 of 2024, the Survey Amendment Regulations, Legal Notice number 71 of 2024, and the Land Adjudication Amendment Regulations, Legal Notice number 76 of 2024, are deemed to have met the requirements set out at Section 13 of the Act and are further deemed to have been approved by the Senate. Kindly be guided. Thank you. Honorable Senators, you may walk in and take your seats. Take your seats, Honorable Senators. I've got another communication to make. Honorable Senators, as you may recall, at the sitting of the Senate held on Wednesday, 24th of July, 2024, the Senator for Kakamega County, Senator Dr. Boni Kalwale, MP, was called upon to move the motion for consideration of the report of the Standing Committee on Finance and Budget on the Senate nominees on behalf of the county governments to the position of member of the Salaries and Remuneration Commission, SRC. Before the Senator could proceed to move the motion, he saw the intervention of the chair through a point of order on the grounds that new information that had been presented to the committee relating to one of the interviewed candidates for the position. The Senator stated that the new information was received after the committee concluded its report and tabled the same in the Senate. In the point of order, Senator Dr. Boni Kalwale MP informed the Senate that on the 24th of July 2024, the committee received correspondence from the University of Nairobi indicating that one of the candidates, Honorable Abdurrahman Ali Hassan, was conferred with a bachelor's degree in Arts, Gender and Development Studies on 19th December 2008, and that the candidate was a student at the said university between 2005 and 2008. The Senator further informed the Senate that the contents of the letter received on the 24th of July 2024 contradicted an earlier letter received on the 22nd July 2024 from the same university, which indicated that the certificate submitted for verification by Honorable Abrahaman Ali Hassan was not genuine and that it was not issued by the University of Nairobi. Senator Dr. Halale also informed the Senate that during the interview, Honorable Abrahaman Ali Hassan was ranked first, but that following receipt of a letter from the said University of 2024, the committee had dropped him from the recommended list of candidates. From the foregoing, the Senate ordered the direction of the Speaker on how to proceed with the motion, stating that I would like you to guide us, because if then the certificate is genuine, it means we have no grounds to knock out that candidate from the list. Therefore, his name should be before the House. The senators who rose in support of the point of order by Senator Dr. Halwale MP, including Senator Johnson Mungatana, MP, Senator Richard Onyonka, MP, Senator Enoch Wambua, MP, and Senator William Kisang, MP, expressed concern on the authenticity of the two letters from the same institution and urged the Senate to exercise caution. Now, honorable senators, given the circumstances, I directed Senator Dr. Boni Halale, MP, to table the letter received on the 24th of July 2024 from the University of Nairobi, and thereafter a ruling on Tuesday the 30th of July 2024 after examining the matter. Consequently, the motion of the Standing Committee on Finance and Budget on the Senate nominee to CRC was deferred pending the ruling, which I now proceed to make. Honorable Senators, as a way of background and to put the matter into context, at the sitting of the Senate held on Tuesday, the 11th of June 2024, I issued a communication relating to a vacancy arising in the membership of the Salaries and Remuneration Commission. In the communication, I stated that via the letter reference EOP, /cap 26, /4A, volume 3, /175, dated the 2024, the Office of the Clerk received a notification from the Chief of Staff and Head of Public Service that the tenure of 6 members of the Salaries and Remuneration Commission was scheduled to lapse on the 10th of September 2024. This included the nominee of the Senate on behalf of the county governments pursuant to Article 232(b)(7) of the Constitution. In the notification letter to the Senate, the Chief of Staff and Head of Public Service requested each nominating body to forward the names of 2 persons of either gender to the Cabinet Secretary for the National Treasury and Economic Planning for transmission to His Excellency the President for appointment. Pursuant to Standing Order 771 of the Senate, I refer the matter to the Standing Committee on Finance and Budget for consideration. The committee was required to undertake the following. 1. Advertise the position by notice, published in the Gazette, a newspaper of nationwide circulation, and the Senate website, inviting applications from suitable candidates. 2. Longlist the applicants and cause the list to be published. 3. Shortlist the candidates that meet the set criteria and cause the list to be published. 4. Facilitate public participation on the suitability of shortlisted candidates. 5. Conduct the interviews of the shortlisted candidates. And lastly, table a report for consideration by the Senate. I thereafter directed the committee to observe the timelines highlighted in the notification letter from the Chief of Staff and Head of Public Service for the Senate to make determination on the nominees on or before 31st of July 2024. Now, Honorable Senators, pursuant to Section 7.2 of the Salaries and Remuneration Commission Act, the Standing Committee on Finance and Budget published an advertisement for the position nominee of the Senate on behalf of county governments to the Salaries and Remuneration Commission on the 2024. In the advertisement, candidates were requested to submit their applications by 3rd of July 2024 at 5 p.m. The committee embarked on the interview exercise on the 19th of July 2024 after long-listing and shortlisting the candidates, and subsequently prepared a report which was tabled on Tuesday the 23rd of July 2024. The tabling of the committee report was pivotal, as it was the first time that the committee was making available its findings to the Senate, and in so doing, making the report available for public information and scrutiny. Following the tabling of the Standing Committee report, the chairperson, as is standard procedure on such undertaking, gave notice of motion pursuant to Standing Order 60 of the Senate during the morning sitting of Wednesday, 24th of July, 2024. In the notice of motion, the Standing Committee recommended 2 candidates for consideration for nomination to the position of members of the Salaries and Remuneration Commission pursuant to Article 232B7 of the Constitution and Section 7.2 of the Salaries and Remuneration Commission Act. Honorable Senators, appreciating the timelines given for submission of the names of the 2 nominees from the Senate, the substantive motion for consideration of the committee report was scheduled in the order paper for the afternoon sitting of Wednesday, 24th July 2024. It was at this point that Senator Dr. Boni Halwale, MP, raised the point of order highlighted above. The point of order was a legitimate concern as it brought to light 2 letters from the same institution that gave contradicting information to the Senate. I therefore find the point of order merits consideration, as the information contained in the correspondence from the University of Nairobi would in either case positively or negatively impact the nomination of the candidates. Honorable Senators, the matter which required the Speaker's intervention arising from the point of order by Dr. Halwale MP was twofold. 1, admissibility of the letter received on the 24th of July 2024, and 2, if the answer to 1 is in the affirmative, the procedure to be followed in examining the letter in the context of the motion already and the evidence adduced for the committee to arrive at the recommendations made. To address the first concern, I have previously ruled that in undertaking an assessment of documents tabled in the Senate as evidence, one must be satisfied that the evidence tabled is from a source which by parliamentary practices is official and verifiable. After reviewing the letter received on the 24th of July 2024, I established the following. A, the letter reference UON/AA/CC/1/2022/1 is dated the 22nd July 2024, and that the letter is ostensibly signed by an individual by the name Mr. Emmanuel Mumba for the Registrar of Academics, and that the letter is on the letterhead of the Deputy Vice Chancellor, Academic Affairs of the University of Nairobi. In this respect, I find that the letter meets the admissibility criteria mentioned above. The next question, therefore, is that required my determination was the procedure to be followed in addressing the letter in the context of the motion already before the Senate. This process requires authentication. This is an undertaking that the Speaker, in the present context, is ill-equipped to perform. From my perspective, the organ of the Senate that has an intricate understanding of the matter at hand is the organ that undertook the interview process. It is for this and other reasons that the Constitution and Article 124(1) gave power to either House of Parliament to establish committees. Select committees are agents of the Senate, are tasked with functions that would otherwise be cumbersome or difficult for the entire Senate sitting in plenary to perform. Besides, the nomination of candidates to an institution as important as the SRC cannot be brought to disrepute on account of lack of due diligence on the part of the Senate. As you're all aware, the matter of academic credentials of public officers is a matter that has been in the limelight in the recent past, thus necessitating the Senate to thoroughly scrutinize certificates and other testimonials presented by candidates for appointment to public offices. Honorable Senators, I therefore direct that this matter be referred back to the Standing Committee on Finance and Budget for consideration. The task before the committee will be limited, and I repeat, the task before the committee will be limited to consideration of the 2 letters from the University of Nairobi in respect of the candidate in question, Honorable Abdurrahman Ali Hassan, and to establish the correct position. The committee will in no way reopen the interview process. Again, repeat. The committee will in no way reopen the interview process. I further direct the Standing Committee to table a report on or before Tuesday, the 6th of August, 2024. In terms of the way forward, depending on the outcome of the report of the Standing Committee to be tabled on the 6th of August 2024, Standing Order 71 states as follows. After the question has been proposed on a motion, the motion shall be deemed to be in the possession of the Senate, and such motion shall not be withdrawn without the leave of the Senate. For the avoidance of doubt, I wish to point out to all honorable senators that the motion on the Senate nominee to SRC is not yet in the possession of the Senate, as it has neither been moved nor seconded, and hence no question therefore has been proposed. Standing Order 61(1) and 2 states as follows. A notice of motion may be withdrawn by a senator who gave the notice. 2, a notice of motion withdrawn under paragraph 1 may be given again either by the same or by any other senator. Upon tabling of the report on the candidate in question, the committee will therefore have these options. 1, proceed to move the motion for which the notice was given on Wednesday, 24th July, 2024, or withdraw the notice of motion given on Wednesday, 24th July, 2024, so as to facilitate giving another notice of motion. The Senate is accordingly guided. Thank you. Yes, what is your point of intervention, Majority Leader? All the honorable senators, proceed to take your seats, please. Take your seats. Majority Leader, you have the floor.
Oh, okay. Mr. Speaker, I want to thank you for your very wise decision. The House stands guided, but maybe just a few points of concern on procedure and also guidance on your part. This is a very intricate matter for which the whole Senate is interested. We are doing this, or we are undertaking this exercise on behalf of county governments, Mr. Speaker, and the people that we represent in this House. Would it be in order, Mr. Speaker, if I request that in future, so as to be able to keenly follow, just 2 things that I want to request. Number 1, so as to be able to keenly follow your flow of thought in arriving at such a crucial decision such as this, immediately you arise to give your ruling. If we can either be furnished with the same by a hard copy, which will be difficult because it will be difficult for Sergeant at arms to move around as you speak, or at least soft copy, Mr. Speaker, because it's difficult to follow through such a lengthy statement while listening to you, Mr. Speaker. It would be nice to follow through so that we are guided, Mr. Speaker, and appreciate the thoughts that have gone into arriving at that decision. Second and most important, Mr. Speaker, is a guidance that you have given to the committee that they undertake the exercise, but that in no way means that they redo the interview in its entirety. I hope in the amended version of the motion, should they choose to pursue the second option as you have guided, Mr. Speaker, then they will inform the House, because this is for the records. And there are many other times that such a matter may appear before the Senate, and history will be used to guide the House on how to make such decisions, on what will have informed their decision either way, and what process they will have followed. I know for a fact, Mr. Speaker, that the letter that was tabled by Senator Boni Halwale is purportedly from this candidate. Therefore, it will be important that they inform the House what procedures they have followed as a committee to establish that indeed this letter comes from the University of Nairobi. Because you know, initially, there was also another letter. Therefore, for just clearance of doubt, as we make a vote on that decision eventually, Mr. Speaker, can we humbly request that they guide the House to appreciate what measures they will have undertaken to establish which of the two letters is authentic and what is the proper position with regards to the qualifications of this gentleman. I thank you, Mr. Speaker.
Yes, Senator Boni.
Thank you, Mr. Speaker. Mr. Speaker, I've heard you, and my majority leader, stroke minority leader, stroke leader of Broadbest. Mr. Speaker, maybe you might have going forward to guide the House that if, for purposes of this kind of exercise, a candidate is supposed to utter such a testimonials, he should come with authenticated copies so that it saves Parliament the trouble of becoming a policeman. Thank you, Mr. Speaker.
Yes, Senator Kajwang, what is your intervention?
Mr. Speaker, I rise pursuant to Standing Order 227 that talks about engagement of experts. And Mr. Speaker, I listened to the long communication that you have made, and you have admitted also that as a Speaker, the verification of authenticity of records and signatures is a matter that you are ill prepared to deal with. And I just wanted to point the committee to which you have committed this task to not be shy from asking the clerk to get experts with the skills and with the expertise and subject matter knowledge to allow the verification of the letters that are in contention. But ultimately, Mr. Speaker, this is a Senate's nominee to the SRC. Now, that is a person who perhaps will be looking at the interests not just of the Senate, but of devolved governments. And this is a very, very important role. Mr. Speaker, in the past, I know that we have always favored a former member to be the Senate's nominee. I'm not saying it's automatic, but it has always been desirable. But ultimately, it depends on the persons who applied. It depends on how they performed at the interview. We wouldn't want a situation where a letter is brought in that then alters the rules of the game to look like there was a preferred candidate that the committee had in mind. So, Mr. Speaker, just on the point of when Senator Boni Khalwale was talking about the committee being reduced to policemen, I wanted to advise him that we have the power to engage experts. And I believe that some of those experts are state or public resources which can be called upon to do authentication without occasioning additional expenditure. Thank you, Mr. Speaker.
Thank you. Let's leave it at that. The chair of the committee, Senator Robo, you've heard the concerns of your colleagues, so as you retire to look at those letters, kindly address those concerns so that we have a very comprehensive report that is addressing the concerns that have been raised by your colleagues. Next order.
Order number 3, messages. Order number 4, petitions. Order number 5, papers.
The Senate Majority Leader.
Thank you, Mr. Speaker. Mr. Speaker, I never knew that the County Assembly of Kakamega can have a better PA than the Senate. Mr. Speaker, sir, I beg to lay the following papers on the table of this Senate today, the 31st of July, 2024. Being, Mr. Speaker, the Pest Control Products Labeling, Advertising and Packaging Regulations, Legal Notice number 99 of 2024. And 2, the Pest Control Products Inspection and Certification Regulations, Legal Notice number 100, 2024. 2024. 3. The pest control, importation and exportation regulations, legal notice number 101, 2024, and the pest control products, fees, and other charges regulations, legal notice number 102, 2024, and finally, Mr. Speaker, the pest control products disposal regulations, legal notice number 103 for the year 2024. I thank you, Mr. Speaker.
The Chairperson, Standing Committee on Budget and Finance.
Thank you very much, Mr. Speaker. I beg to lay the following paper on the table of the Senate today, 31st July 2024. Report of the Standing Committee on Finance and Budget, consideration of the National Assembly Amendment to the Equalization Fund Appropriation Bill, number 2, Senate Bill, number 30 of 2023. I beg to lay.
Next order.
Order number 6, notices of motion. Order number 7, questions and statements.
Statements pursuant to Standing Order 53-1. Senator James Lomenan.
Thank you, Mr. Speaker, sir. I rise pursuant to Standing Order 53-1 to seek a statement from the Standing Committee on Roads, Transportation and Housing regarding the rehabilitation and grading of Maram roads in burden-prone areas in Turkana East, Turkana South, Loima constituency in Turkana County. Mr. Speaker, sir, roads in the burden-prone areas in Turkana East, Turkana South, and Loima sub-counties in Turkana County have for a long time remained nearly impassable. This has stilled economic development in these areas and severely undermines efforts to combat burdenry as the depopulated nature of the roads hinders the mobility of security personnel. Mr. Speaker, sir, there is a critical need to rehabilitate and grade roads in the said areas to ensure the safety of residents and the enhancement of development initiatives. I therefore request the committee to 1. Outline any plans by the government to rehabilitate and grade the following Maram roads. 1. Turkana East constituency, Suguta sub-county. A. Kamurio Kapedo Road. B. Kamurio Lomelo Napeitom Road. C. Amaler Alosia Lokwamosing Road. Roman number 2, Turkana South constituency, Aro sub-county. A. Napeitom Lomelo Tot Road. B. Juluk Kalomwe Nariumoru Kasei Road. C. Kainuk Lotongot Lochakula Amalel Road. D. Kakong Nariamaoi Locharesokon Namambu Kalosia Amalel Road. Roman number 3, Loima constituency, Lokriama sub-county, Naipa, Lorenkipi, Lokwakipi Road. B. Kalemunyang, Lorenkipi, Lokwakipi Road. 2. Provide timelines for completion of rehabilitation and grading works on the said roads. Thank you, Mr. Speaker, sir. Sir, the second statement, I rise pursuant to Standing Order 53-1 to seek a statement from the Standing Committee on Land, Environment and Natural Resources regarding the unauthorized occupation of Turkana South National Reserve by pastoralists from the neighboring West Pokot County. Mr. Speaker, sir, the presence of pastoralists and their cattle at the Turkana South National Reserve threatens biodiversity and has disrupted the ecological balance of the National Reserve. Grazing cattle have scared and driven away wildlife to the drier and less hospitable regions of the reserve, severely affecting their natural habitat and behavior. Additionally, the pastoralists have been responsible for killing numerous wildlife. Mr. Speaker, sir, not only have these protected lands been encroached upon by the pastoralists who disturb wildlife, but they are also infiltrated by bandits and cattle rustlers who have continually launched attacks on residents of the neighboring Turkana East and Turkana South sub-counties in Turkana County. This has exacerbated insecurity and instability in the region. Moreover, their occupation violates the gazettement by the Ministry of Interior and National Administration of the reserve as disturbed, dangerous, and non-settlement zone due to banditry activities. I therefore request to the committee, 1. State any immediate steps taken by the Kenya Wildlife Service to eject all unauthorized settlers from the Turkana South National Reserve. 2. Outline any security protocols put in place to prevent any subsequent unauthorized occupation of the reserve, stating whether there are plans to deploy additional security personnel to monitor and patrol the reserve. 3. Provide details of any other initiative by Kenya Wildlife Service to restore the integrity of wildlife and the reserve. 4. Explain any long-term measures put in place by the Ministry of Interior and National Administration and the National Police Service to guarantee the safety and security of the residents of Turkana East and Turkana South sub-counties and to deter further illegal activities by bandits and cattle rustlers taking refuge in the reserve. Thank you, Mr. Speaker.
Senator Fanyandarwa, Senator John Maitho.
Honorable Speaker, sir, I rise pursuant to Standing Order 53-1 to seek a statement from the Standing Committee on Roads, Transportation, Housing regarding the status of insurance cover of motor vehicles belonging to the county government of Nyandarua. In the statement, the committee should, number 1, specify the total number of vehicles belonging to the county government of Nyandarua, indicating how many of the vehicles are insured under the third-party motor vehicle insurance cover, as well as those under the comprehensive motor vehicle insurance cover. Number 2, disclose the details of insurance provider or providers contracted by the county government of Nyandarua to insure the said vehicles, including details of the agreement between the county government and the insurance provider or providers and indicate the annual insurance premiums payable by the county government of Nyandarua. Number 3, state the number of accidents involving the county government vehicles that have occurred since 2013 to date, clarifying on whether insurance providers repaired the vehicles or paid compensation to the county government. And number 4, explain the circumstances that have led to the abandonment at police stations across Nyandarua County of several county government vehicles involved in accidents, stating whether these vehicles were insured at the time of the accidents. I thank you very much, Honorable Speaker.
Senator Richard Onyonka.
Thank you, Mr. Speaker. I hear Honorable Cherargei is extremely excited that I'm told the...
Senator Onyonka, proceed with your statement.
I'll proceed, sir.
Please do.
My apologies. Mr. Speaker, I stand here, I rise in pursuant to Standing Order number 53-1 to seek a statement from the Standing Committee on Lands, Environment and Natural Resources regarding the exploration of minerals in Kenya. In the statement, Mr. Speaker, I would want the committee to provide a report on the status of exploration of all discovered minerals in the republic known as Kenya, providing a comprehensive geological map showing the locations of the minerals, the mining sites in Kenya, and approximately what their values are. Mr. Speaker, the committee, number 2, should provide a comprehensive list of all licensed companies in mineral exploration and in the mining industry, indicating their respective revenue contribution to the government in terms of tax and local communities through taxes, royalties, and corporate social responsibility activities. Mr. Speaker, 3, I would want the committee to outline any measures put into place to secure rare minerals which have been discovered in game reserves, private animal conservancies, and on private land within our borders. Mr. Speaker, the committee should investigate claims of rare mineral deposits having been discovered in private animal conservancies and kept undeclared, and if substantiated, any steps that the government is conducting to curb illegal mining and smuggling of the same out of the country, and to hold to account any individuals found culpable. Mr. Speaker, number 5, the committee should give us a report on who is mining soapstone in Kisii County, since I have been informed that the company is mining that soapstone is from China, and they're exporting that soapstone to China, and yet there was a presidential declaration that the Chinese company should set up a factory in Kisii so that it can employ our people. Thank you, Mr. Speaker, for giving me this opportunity.
Senator Mohammed Chute.
Thank you very much, Honorable Speaker. Honorable Speaker, I have a request for a statement on the operation of Northern Rangelands Trust Fund, which is known as NRT in Marsabit County. Mr. Speaker, sir, I rise pursuant to Standing Order 53-1 to seek a statement from the Standing Committee on Lands, Environment and Natural Resources regarding the operations of Northern Rangeland Trust in Marsabit County. Mr. Speaker, sir, I sought a similar statement on 18th April 2023, but did not receive a satisfactory response since the Ministry of Environment, Climate Change and Forestry indicated that they could not provide the requested information because there existed a gap in the legal and policy framework on carbon markets. Mr. Speaker, sir, the Climate Change Act 2016 has since been amended to provide for the regulation of carbon projects and trading in Kenya. The amendment came into force on 15 September 2023. I therefore request the committee to provide a comprehensive report on the operations of Northern Rangelands Trust, known as NRT, in Marsabit County, indicating their areas of operation. Number 2, clarify whether NRT intends to expand and set up an operation in new locations, and if so, provide a list of respective locations. Number 3, disclose the amount of funds claimed by NRT on behalf of the county government of Marsabit for carbon credit discounting, indicating the amount that was paid to the local community. And finally, number 4, provide a list of all organizations currently representing Marsabit County as agents in NRT. Thank you very much, Honorable Speaker.
Senator Professor Tom Ojenda. The statement is dropped. Senator Muruma.
Thank you, Honorable Speaker, for this opportunity to request for 2 statements. The first one is on the status of World Bank funded projects for the upgrade of the water supply and sewerage systems in Taita Taveta County. Mr. Speaker, sir, I rise pursuant to Standing Order 53-1 to seek a statement from the Standing Committee on Land, Environment and Natural Resources regarding the status of the World Bank funded project for the upgrade of the water supply and sewerage systems in Taita Taveta County. In the statement, the committee should, 1, provide a status upgrade of the World Bank funded project for the upgrade of the water supply and sewerage systems in Taita Taveta County, whose scope includes the construction of an integrated water supply system in Voi, Taveta, and Undani towns, as well as modern sewerage and treatment systems in Voi, Taveta, and Matati towns. 2, disclose details regarding the tender opening and evaluation processes for all tenders floated relating to the project, stating the names of the contractors that submitted bids, the winning bid amount, as well as the contract details, to include the date of award and scope of the contract. 3, indicate in the total cost of the project, disclosing what the World Bank has so far released and the pending amount. And 4, outline any measures put in place to fast-track the completion of the project and state the projected completion date. Mr. Speaker, I have a second statement concerning the change of user of the land in Taita Taveta County held by Voi Point Limited. Mr. Speaker, sir, I rise pursuant to Standing Order 53-1 to seek a statement from the Standing Committee on Land, Environment and Natural Resources regarding the change of user from agricultural to commercial land in Taita Taveta County held by MS Voi Point Limited on leasehold tenure. In the statement, the committee should, 1, outline reasons for the change of user from agricultural to commercial of the land in Taita Taveta County held by MS Voi Point Limited on leasehold tenure. 2, state whether public participation was undertaken before the exercise, and if so, provide a schedule of the venue, time, the attendees of the public participation meetings. 3, clarify whether the process of change of user complied with all other applicable legal and constitutional requirements. 4, indicate the status of the caveat imposed on the land by government, as well as the status of the lease of the land in light of the change of user. And 5, state the fate of the residents of Mkamenyi village who are to be allocated part of the land for resettlement. I thank you, Mr. Speaker.
Senator Fomero, Senator Gathuri Murungi.
Mr. Speaker, sir, I rise pursuant to Standing Order 53-1 to seek a statement from the Standing Committee on Justice, Legal Affairs and Human Rights regarding the governance issues in Meru County. Mr. Speaker, sir, there have been governance issues in Meru County since the general elections of 2022, marred by an ending conflict between the governor of the county and the County Assembly of Meru. Most recently, Mr. Speaker, the County Assembly attempted to impeach the governor, who sought reprieve in the High Court at the Meru Law Court. The court directed the parties to attempt to resolve the matter through alternative dispute resolution (ADR) mechanisms facilitated by the Njurincheke Supreme Council of Meru Elders. Mr. Speaker, sir, I am aware that the matter is still active in court, and without offending the provisions of Standing Order 101 in relation to the Honorable Judge and the orders of the court, I request the committee to, number one, explain the linkage between bodies outside the judicial structures and the court system, explaining the role of such bodies in facilitating the solution of matters found in the courts. And two, outline any measures put in place to ensure continuous capacity building for judicial officers on evolving cultural dynamics within the stations of the judiciary. And three, explain any measures put in place to ensure that NDR mechanisms are sensitive to cultural dynamics and not offend the right of parties for fair hearing. And Mr. Speaker, as I issue this statement, I want to confirm to Mboni Karwale and the members that I'm a senior member of Njurincheke Council of Elders. And as
Senator for Meru, don't debate your statement.
Elder,
have your seat. Don't debate your statement, please. just take your seat. Statements pursuant to Standing Order 58, the Honorable Mohammed Chute.
Thank you very much, Honorable Speaker. Today I have a statement on false reports of my arrest by the Ethics and Anti-Corruption Commission. Mr. Speaker, sir, I rise pursuant to Standing Order 58 to make a statement regarding the false reports of my arrest by the Ethics and Anti-Corruption Commission, EACC. I would like to categorically state that I was not arrested by EACC on Thursday, 11th June 2024, as falsely stated by the Chief Executive Officer and the spokesperson of the Commission. Mr. Speaker, sir, in respect of my appearance before EACC on the specified date, I wish to clarify that I was at EACC offices upon invitation. I believed that the invitation arose from the several complaints I had made to the Commission regarding misappropriation of funds in Marsabit County. Mr. Speaker, sir, upon appearance at the EACC alongside my lawyer, I was informed by investigating officer that the information required of me then related to the ongoing investigation into alleged acts of corruption by the governor of Marsabit County and not myself. Honorable Speaker, I was asked about approximately 7 million shillings transferred by myself and my spouse to the governor in August 2017, which was before His Excellency Muhammad Ali and myself were elected governor and senator respectively. I explained that the transfer related to a fundraising event that were held at Lake Regency. I was also asked about 2 funds transfers, as well as 2 vouchers of 1.4 million shillings and 6.4 million shillings paid to my company by the county government of Marsabit. Mr. Speaker, sir, it is quite concerning that immediately after the CEO and the spokesman, thereafter, the CEO and the spokesperson of the Commission made a false press statement that I had been arrested and was under investigation for conflict of interest and theft of public funds. to the tune of 365 million, as well as embezzlement of public funds to the tune of 2 billion shillings. At no point was I questioned on any of these matters, Honorable Speaker. I therefore challenge the CEO and the spokesperson to make public any evidence contradicting my account. In any case, Honorable Speaker, the statement recorded by myself on the said date could be sufficient evidence. Mr. Speaker, sir, it is my considered view that the CEO's actions are retaliatory and driven by personal vendetta stemming from my remarks during the sitting of the Senate on 26 June 2024, calling for disbursement of EACC failing to fulfill its mandate. And I will say it again and again and again. I have therefore instructed my lawyer to institute a legal suit against the CEO and the spokesperson for defamation and character assassination. In the coming days, I will also be seeking an update on the progress of investigation by EACC into the issues raised in the complaint I submitted to the Commission. These complaints date back several years, including period before I was elected senator. I thank you, Honorable Speaker.
Now, honorable senators will allow 30 minutes of intervention. It is now 3:32, so we will terminate at 4:02. Senator Manzo.
Thank you, Mr. Speaker. Mr. Speaker, I would like to deal with the matter of the Honorable Lamunen, Senator for Turkana. Mr. Speaker, from Nairobi to Kapendo, where he was talking about a road which should be going into Turkana, is 300 kilometers, and then within Turkana is about 400 kilometers, Mr. Speaker. Mr. Speaker, from a recent report on television, Citizen TV, it showed that particular area and Kenyans from that county, Mr. Speaker, complaining of how transport it is very difficult, that no private persons invest there in transport, that unless the police assist the residents of Turkana, that the traveling is very difficult, Mr. Speaker, and therefore doing of business in that particular county is very difficult, owing to our very old colonial bridge. Mr. Speaker, I'll want to support his statement so that Kenyans can be served equally, and that a serious effort be made there by the Ministry of Transport to make sure that, although not everywhere there are good roads, and also together with the devolution, that the people of Turkana are better roads and better for security. Secondly, on the Meru matter, Mr. Speaker, this is really new jurisprudence. As much as ADR is advocated by the courts, and even that there is an ADR Act, Mr. Speaker, this is a matter which was within the jurisdiction of court, and in the alternative also within the jurisdiction of this House, Mr. Speaker. Therefore, it is such a matter constitutionally which should be dealt by this House or the House in Meru, and in the event there is a suit filed, there is a likelihood, just like the Honorable Senator has said, that is a member of Juru Jeke and is also a member of this House, and therefore likely to participate when the matter comes to the House. Mr. Speaker.
What is your point of order, Majority Leader?
Sorry, Mr. Speaker, apologies to my colleague for interrupting him, but it's just a concern. There is a guidance perhaps you should have given, Mr. Speaker, on how much time you give to each individual senator, because the allocated time is only 30 minutes. To best of my recollection, I think Senator Mahanzo has already done 5, so leaving 25 for the rest of all of us. Mr. Speaker, perhaps you could guide so that each senator who rises to comment can be limited to a specific time period. My kind indulgence.
Now, honorable senators, the time allowable for intervention on statements is not more than 30 minutes. And that's why I've given the maximum to the entire Senate. So as you speak, be mindful of that fact. I know that a senator rising to speak has 20 minutes to speak. But again, you have to view that against the standing order that gives 30 minutes for intervention on statements. So if we can keep it 2 minutes each, then we'll be able to hear as many as will be willing to speak. Senator Manz, you've done only 1 minute. You may proceed to take your second.
Thank you. Therefore, Mr. Speaker, on that particular matter of the Senate, of the county of Meru, Mr. Speaker, that is clearly a matter either within the jurisdiction of court or within the jurisdiction of Senate. Any other arbiter referred to, Mr. Speaker, may be prejudiced in one way or another, and therefore, I want to support that statement, and now that the courts have referred it to the jury jeke, then the jury jeke should make a very quick decision and send it back to the court so that we can be on course to sort out matters pending in Meru, bearing in mind this county, Mr. Speaker, has not had ministers, departments, is operating on a half budget, and therefore it cannot be like this forever. There must be a way that the issues in Meru must be settled and the county of Meru operates like other counties in the country. I thank you, Mr. Speaker.
Majority Leader.
Mr. Speaker, I would just like to make a brief comment on the statement by the Senator for Meru on this very strange ruling, actually, that emanated from the courts this week. And it is something that I wish Justice and Legal Affairs Committee can guide us. There has been a particular focus on Parliament and how it does its work, and rightfully so, Mr. Speaker, because we are representatives of the people. But, Mr. Speaker, I feel as a country, and Justice and Legal Affairs Committee needs to point us in that direction, we equally need a conversation on the performance of our judiciary, Mr. Speaker, because it is increasingly becoming clear that we vested such significant authority to our judicial system, and rightfully so, Mr. Speaker, but may have missed a step with regards to how they are held to account, Mr. Speaker, for their decisions and actions. Take this case, for example, where a judge, on their own volition, Mr. Speaker, without the request of Jurin Cheke or the leadership or anyone, just chooses to refer the matter to this institution for a matter that is properly provided for in law. The County Assembly, Mr. Speaker, is guided and draws its authority from this same constitution, Mr. Speaker, to oversight the actions of the county government of Meru. If it has reached a point where they feel, the members of the County Assembly, Mr. Speaker, that the citizens of Meru are not getting justice in terms of services from their county government, Mr. Speaker, then they are allowed to carry out their constitutional mandate in whichever way that they deem fit, Mr. Speaker. And therefore, I find that this was a strange decision, Mr. Speaker, and there are many such others, Mr. Speaker, where a judge makes a decision and you wonder whether they appreciate fully the impact of the consequences of their decisions, Mr. Speaker. And there are many such examples, Mr. Speaker. There are many other things that we could speak about. Lastly, you know, Mr. Speaker, just in mentioning how these decisions are increasingly becoming the norm, actually, rather than the exception, this week again there was an, you know, I'm a fan of football, Mr. Speaker, and I follow a lot what happens in our football circles. For a long time, Football Kenya Federation has been unable to hold elections because of court action. We have provided by law, Mr. Speaker, tribunals. And how tribunals work, Mr. Speaker, is that the judges that sit there, Mr. Speaker, or the representatives, the jurists that sit in these tribunals, Mr. Speaker, have the technical knowledge of how some of these institutions operate. We have the water tribunal, rent tribunal, and the sports tribunal. You find a judge issuing orders ex parte, like was the case in the matter of FKF elections, Mr. Speaker, and gives a mention, the next mention date to be sometimes in October, long after the officials who are present in office would have since left office. This in light of the fact that we are about to host...
Senator Osotsi.
Thank you, Mr. Speaker. Mr. Speaker, I wish to make a comment on the statement by Senator Methu
on the issue of management of motor vehicles insurance. I think, Mr. Speaker, this statement is timely, and I would encourage the committee concerned, Committee for Roads and Transportation, to take keen interest on that matter, because it's an issue affecting many other counties, and if they can extend to include the management of motor vehicles in various garages. Mr. Speaker, in many counties we have many of the county vehicles which are stored in various garages. Some of the vehicles the issues are very minor, but they have been kept in garages for so long and nothing is being done. So I would wish that that statement includes the issue of motor vehicles which are kept in various garages across the country. Mr. Speaker, I also want to comment on the statement by Senator Onyonka on exploration of minerals. Mr. Speaker, last week we were discussing here the issue of minerals, and we said that we would like to see more transparency, more accountability in the process of managing mining in this country. Mr. Speaker, exploration is a serious matter, and we have companies which are exploring minerals which are not following procedures. They come and claim they are exploring, but in the real sense they are actually mining. One of the companies is Shanta Gold, which is exploring gold in the boundary between Vihiga and Siaya. But in the true sense, they are actually mining gold, and they are taking advantage of the people. There is no public participation, there is no proper engagement, there is no CSR. Mr. Speaker, I think this is a very serious matter, and I thank Senator Onyonka for bringing up this matter, and the committee concerned should dig deeper into this matter so that such companies which exploit our people are brought to book and action is taken against them. Mr. Speaker, I support.
Senator Chiranke.
Mr. Speaker, thank you very much. I want to comment on the statement by Deputy Speaker, Senator Katuri Murungi, on the issue of decision by Mary Court. Mr. Speaker, I was shocked as a legal practitioner that with the reading of Article 159, when you want to do ADR, the exception has been provided by Article 159.3 that traditional dispute resolution mechanism shall not be used in a way that contravenes bills of rights, repugnant to justice and morality, and results outcomes that are repugnant to justice or morality. C, it is inconsistent with this constitution on any written law. So, Speaker, under Article 181, the removal of a governor is a constitutional matter. I'm happy that Njuri has recused himself from that matter and has written to the High Court to move themselves from that matter. I find it mischievous, with all due respect for that High Court judge, to refer matters that should not be entertained under ADR, because this is a constitutional matter. So, Speaker, if it was issues of marriage, succession, and other matters that are of personal nature in the definition of law, then the High Court could refer. Mr. Speaker, the judiciary must be called out. I saw in a matter of Garissa County, where the governor has appointed more than 30 chief officers. The members of public went to seek an injunction, but the judge at the Garissa High Court ignored and allowed the process of vetting and appointing of 30 chief officers, Mr. Speaker. We have seen the matter of KFKF Football Federation, Mr. Speaker. So is now judiciary or judges a stumbling block against Kenyans seeking justice? I tend to agree so. I want to thank the High Court judge in Eldoret when Governor Sang reappointed CCM without seeking recourse, Mr. Speaker, to the County Assembly Approval Act. The High Court ordered him to do vetting again, Mr. Speaker. And therefore, those cases must be occupied.
Senator Richard Onyonka.
Mr. Speaker, I'm just going to make a very short comment about the matter that Honorable Chute raised. And I want to bring the attention of this...
Senator Onyonka,
yes.
That statement is not available for debate under Standing Order 58. It's a personal statement.
Oh, my apologies, sir. Mr. Speaker, I got a bit confused. I wanted to say that I have seen that Nchurincheka has actually made a withdrawal of the matter from the High Court. And I just want to mention to this House that if there is anything that we need to do is make sure that we protect and ring-fence our responsibilities as the Senate and other statutory bodies to make sure that our country is governed well and we maintain law and order. Thank you, Mr. Speaker.
Senator Gloria Oroba.
Thank you, Mr. Speaker. I would like to make a comment on the Deputy Speaker's statement with regards to the county government of Meru and the issues that they're having there, Mr. Speaker. My sentiments to this is that it appears that other parties, including the judiciary, feels that the Senate perhaps does not know the work that we have been mandated to do, Mr. Speaker. And in that essence, I would like to call upon the Committee of Devolution, because we do have a committee here that is in charge of devolution. And I'm wondering what they have been doing throughout this time, even when we were aware that the county government of Meru was actually having issues and going to court, Mr. Speaker. Mr. Speaker, I also want to maybe bring to light that in the event that as a Senate we feel, because I know that as senators, most of us here, we've had conversations, we feel that the county government of Meru is not working and it is not able to actually deliver. In the event that this is a common feeling, Mr. Speaker, we can also bring a petition here in terms of dissolving that county, Mr. Speaker. But having outside parties telling us that they are going to sit on alternative dispute resolution when we are still here, when we are in session, Mr. Speaker, I think it's an insult to this institution and to this House. So therefore, I call upon the Committee of Devolution to either persuade us, maybe through a motion or a petition or something, so that we can be able to handle this matter as a House that is there to support and fiercely defend devolution. Thank you, Mr. Speaker.
Senator Wambua Enoch.
The Speaker, thank you for this opportunity. And I want to just thank the Senator for Meru for bringing this matter up as a statement and for the opportunity for members to ventilate on this matter. Mr. Speaker, two things. One, what the judge did in referring this matter of impeachment to the Nchurincheka was a clear affront against constitutional hygiene. The matter of impeachment is a constitutional issue. In fact, the courts have a role to play at the end of the process if a party in the impeachment is aggrieved. For the judge to go on record and say that this is one of the most complicated and serious cases that he has ever encountered, then the Speaker, without discussing the character of the judge, I wonder then, if this matter is so complicated to a High Court judge, what will happen when he is confronted with serious matters? The Speaker, that was an admission on the part of the judge of serious deficit of capacity to deal with a very simple matter. Mr. Speaker, the second issue is that I would want to challenge the Senator of Meru. I know this may be a bit complicated for him, but to consider going forward to cause to be invoked Article 187 of the Constitution, especially for critical functions and roles in the county government of Meru. Seriously speaking, the Speaker, the county government of Meru is dysfunctional. There will be need to consider transfer of services to another entity of government especially for critical services, so the people of Meru can be served. And Mr. Speaker, I want to declare this on this floor, that when that matter comes here, and I know I should not be doing this, honestly, we must just deal with this Meru issue once and for all. Just finish with it. And if it means the entire assembly going home and the governor going home, so that the people of Meru can also get the benefits of devolution. For now, it is a circus between the assembly and the governor, and the people are suffering. Consider invoking Article 187 of the Constitution on critical services, roles and functions in the county government of Meru. I thank you, Mr. Speaker.
Senator John Methu.
Thank you very much, Honorable Speaker. I also would wish to comment on the statement that has been sought by the Senator for Meru. And Honorable Speaker, just as my colleagues have actually said, this is actually a new, and we were just conversing here with the majority leader. Since this is a constitutional matter that had been brought to the attention of the judge of the level of the High Court, Honorable Speaker, and you say that this matter must be addressed. It's a very serious matter, so you send it back to Jurincheke. Two things, Honorable Speaker. One, the Senator for Meru has confirmed to us that he is a member of the Jurincheke. So how is he supposed to address this matter? If the County Assembly of Meru processes this motion, it will come to this particular house, and he will sit here as a senator, and he has sat on that matter during ADR. The second question we are asking ourselves, if this jurisprudence was what would be carried, what if tomorrow the judges of the Supreme Court, considering a presidential petition, ask the players and the parties to go and for ADR, they ask the National Conference of Catholic Bishops or the Islamic Council or the Council of Imams to go and arbitrate over this matter, Honorable Speaker. And finally, looking at the reading of Article 159 on where traditional dispute resolution mechanisms can be used, it does not come in on a process that is very clear in processing an impeachment motion. It is processed at the County Assembly. After the County Assembly, it comes to the Senate, Honorable Speaker. It has no other route. So for the judge to now say that you are taking this matter to the Jurincheke, and I'm very happy that the Jurincheke of Meru have actually said that they don't have the capacity to look at this matter. And it then brings the question, what if this matter was a matter that had been taken to court in another county that does not have a council of elders? What would have been the ruling of this particular case? So we are very disappointed, and I agree with the leader of majority, Honorable Speaker, that even as we give powers to the judiciary, they must be then also accountable. To whom are they accountable, Honorable Speaker? We as this House are accountable to the people of Kenya after every 5 years. We are subjected to an election after every 5 years. Who are judges accountable to? Even when you have made such an affront to the Constitution, I mean, even basic common sense, Honorable Speaker, who is that judge accountable to? So I would wish to say, just as the Senator for Kitui has said, on this particular matter of Meru, this time, we as a Senate, we have to ensure that the people of Meru actually get justice. They are not children of Aresa God, Honorable Speaker. We have to do everything that we can, including everything.
Senator Methu, that matter is not before us, so we cannot do anything. Just wait till maybe it gets here. Senator Hezana.
Thank you, Mr. Speaker. And I rise to contribute on the statement by Honorable Chute, the Senator for Marsabit, on the operations of the Northern Rangeland Trust in Marsabit County and obviously in the whole of northern Kenya as far as its name is concerned. Mr. Speaker, this statement comes at a time when the President was very clear about foreign organizations meddling in the peace, stability, and sovereignty of our nation. And in the same breath, Mr. Speaker, I would also want to know if NRT can disclose if they have any armory within their headquarters, and if there have been any deaths in the northern parts of Kenya that have been associated with them, particularly for the Samburu community, and what they have to say on that. Mr. Speaker, the carbon credit has been the new gold in northern Kenya. It has been a booming business where NRT is reaping millions of dollars. It is important that they disclose their financial records and make it public so that our people, who majority are illiterate, can be able to follow through on their financial on the financial compensation they are getting from whoever they are selling this carbon credit to. And it is also important that our people are given given enough information on how their land is utilized. And also, we do not see a reflection on the charities and the feedback or giving back they are giving to the community in the livelihoods of the people in the northern parts of Kenya. Thank you, Mr. Speaker.
Senator Bone Alvale.
Thank you, Mr. Speaker. Mr. Speaker, the issue raised by the Deputy Speaker is very serious. Mr. Speaker, there was no motion whatsoever before this judge to give him an opportunity to make this wild order. No motion. He did it on his own volition. And in so doing, he also made a pronouncement inconsistent with the Constitution. And Mr. Speaker, for this reason, I want to appeal to you that in accordance to Article 168 of the Constitution, Mr. Speaker, this judge has invited himself to removal from office. I therefore, Mr. Speaker, so as to send a clear message, please let this Senate move the Judicial Service Commission so that the Judicial Service Commission can then initiate the process of removing this judge. There are so many people who want to be judges. In fact, some of them very young.
What is your point of order, Senator Fak?
Is the distinguished medical practitioner and the majority whip in the Senate in order to attempt to discuss the conduct of a judge of the High Court without a substantive motion before this House.
Thank you, Mr. Speaker.
Boni, you need to adhere to the standing orders. You may not discuss the conduct of an officer who may not get a chance to rebut what you're alleging. So proceed.
Thank you, Mr. Speaker. Mr. Speaker, my second and last comment is on the matter raised by the Senator of Kisii. As mentioned by the Senator of Vihiga, Shanta Gold Limited Company is a big joke, and the Ministry of Mining must up the game. Shanta Gold has been in Kakamega, specifically Ikolomani, Bushiangala village, Isulu. It has been there, Mr. Speaker, for 15 years in the name of exploitation. And they have mined, Mr. Speaker, a total of 168 kilometers of a 2-centimeter diameter chain that goes through the tube they use for extracting.
What is the point of order, Senator Gloria?
Mr. Speaker, I just wanted you to clarify, because you made a ruling based on standing order 111 on contents of speech. And Mr. Speaker, when you read that standing order, it says, neither the personal conduct of the President, nor the conduct of the Speaker, or of any judge, nor the judicial conduct of any other person performing judicial functions, Mr. Speaker. And it says there, because the removal of the office if it's dependent on the Senate. Mr. Speaker, I just wanted to clarify, because also the statement, I wanted you to clarify, the statement that has been brought to the floor of the House by the Deputy Speaker even the contents of the statement is alluding or seeking that a committee of this House actually discuss the ruling that has been made by the conduct of an individual that is on this one. So are we also saying that that statement is out of order?
Senator Gloria, get hold of that statement by the Senator for Kathuri. It's very far from what you're alleging. Proceed and conclude.
Mr. Speaker, Shanta Gold has been in Ekolomani for those 15 years. And Mr. Speaker, they are pretending and they are being allowed to be still to be seen to be carrying out exploration when they are actually gutting away billions of shillings meant for the people of Kakamega. Mr. Speaker, this must be stopped. I was running on time so as to come back to the Senator of Mombasa. Senior Counsel, Senator of Mombasa, you must differentiate between me.
Address the chair, Senator.
Thank you, Mr. Speaker. The Senator of Mombasa is disappointing me. He's a senior counsel. He must be able to distinguish between...
Senator Boni, I've already ruled on the point of order raised by Senator Faki. Please do not go there. If you're done with your intervention, I may proceed to call Senator Eddie Okech.
They have not taken the mic.
Chair,
proceed, Senator Eddie.
Thank you, Chair.
He'll be informed at the lounge.
Yeah,
proceed.
Bonnie will be informed at the lounge. Chair, I want to make a quick comment. Chair, may you protect me from Senator Mogeni? Mr. Speaker, Senator Mogeni is heckling.
Senator Eddie. Senator Mogeni, what is your intervention? You still not to be settled. What is your intervention?
Yes.
Have a seat, Senator Eddie.
My neighbor, Senator of Migori, should know there is some language which is unparliamentary, including using the word heckling. Now, Mr. Speaker, I wanted to inform Senator Halwale that he should not mislead the country by making reference to the Senator of Mombasa 001 as being one of the lawyers who have been inducted into the role of senior counsel. For the record, Senator Halwale, Senator of Mombasa 001, has not been inducted to the role of senior counsel. So you are out of order by referring him to senior counsel Mohamed Faki.
Senator Eddie, proceed to conclude.
Chair, I hadn't even started yet, so I'm just starting.
Proceed.
Chair, I wanted to make a quick comment on a very important issue that Senator Onyonka has raised in this House through this statement on a possibility of auditing all our minerals and being able to account for all those minerals plus those companies that are involved in them, Mr. Speaker. Mr. Speaker, I think this is a very, very serious statement that as a country we must start thinking very critically about the minerals that we have and how we explore them. Because in the current world order, Mr. Speaker, you cannot think about any better opportunity that you can have as a country than any rare minerals that you have in the country to the extent that you can invest in them, Mr. Speaker. I want just to give an example, Mr. Speaker, that the current world order, you cannot think about areas of investment without thinking about what raw materials go into renewable energy. And because of the competition in the world in the area of technology, any smart technology for any smart electronic devices, Mr. Speaker, you cannot have them without thinking about raw materials that are coming out of this country. And Mr. Speaker, there is something called rare earth elements, which if you look at the demand of rare earth elements in the world, Mr. Speaker, at the pace of growth, by 2027, rare earth elements will have a 14% demand. Now, rare earth oxide alone, if you look at China, China has got about 85% control over rare earth oxide. And in this country, Mr. Speaker, our potential for rare earth elements is up to, in fact, over $100 billion. And Mr. Speaker, when you look at our current foreign policy, there is no articulation of even exploration of rare earth minerals in Kenya when we are engaging with the world's superpower in terms of technological advancement like the United States. You would have expected that if we are going to the United States, we have got accounts of these rare earth elements and the minerals that are ensuing from them, like in a county in Kwale, Mr. Speaker, where we have got amazing rare earth elements that have been estimated by experts that could be able to fetch this country even $35 billion, Mr. Speaker. And our debt that we are struggling with in the country today, Mr. Speaker, is barely 100 billion. If you have got rare earth elements in this country that can be able to, if we invest in them, they can be able to give us even up to 100 billion, Mr. Speaker. It will be very, very important that in this new broad-based government that we have, we start thinking critically about data-driven mining, data-driven decision-making in the mining sector, so that we see whether we can be able to explore our minerals to be able to deal with the issue of critical debt stock that we have in this country. Therefore, I want to support this statement and particularly draw the attention of this committee to look at the potential of Kenyan economy with regards to rare earth minerals that we can be able to explore and go ahead and even indicate how much money we need to inject in that sector and the potential revenues in terms of investments vis-a-vis returns of those investments that we can be able to make. Because as somebody who has looked at in this issue, Mr. Speaker, I am sure if you pumped 1.5 billion into the rare earth minerals in this country, you can make up to 30 billion at any given time. That means that every annual turnover on these issues, we can be able to actually even make money that can be able to guarantee us returns that can deal with debt. So I support this statement, and I hope that the relevant committee will look at it.
Senator Mungatana.
Bwana Spika, ningependa kuchukua nafasi hii kukushukuru kwa kunipa nafasi pia na mimi nichangie maoni yangu kuhusu hoja ambayo imeletwa hapa na seneta wa Meru. Bwana Spika, Judicial Service Commission ni kati ya zile jopo ambazo zinaweza kuangalia makosa yoyote ambao mahakimu na majaji wanafanya katika kutoa zile hukumu zao. Kwa hivyo, ningependelea pia kamati hiyo ya JLAC waangalie kama wanaweza kupeleka malalamishi kirasmi kwa Judicial Service Commission kuhusu hukumu ya huyu judge ambaye amesema kwamba kazi ambayo Senate ingefaa ifanye ipelekwe kwa Njuri Chenki. Pia Bwana Spika, kuna hili jambo la kwamba jaji wa mahakama kuu ya Kenya anasahau ya kwamba yule aliyechaguliwa pale ambaye ni governor wa Meru amechaguliwa na watu wote wanaoishi pale Meru. Mimi najua kuna Wapokomo, kuna Waorma wanaoishi pale Meru, kuna Wagiriama, manake Meru ukiwa unashuka hivi wanatuletea miraa sehemu ya huku kwetu. Na kuna watu ambao wanaenda kufanya biashara kule na wamechukua kadi zao za kura kule. Kwa hivyo ikiwa kwamba kuna makosa ama kuna issue yoyote ya kutatuliwa, kwa nini judge anafikiria watu wote, wapiga kura wote wa Meru ati ni wa Meru, kwa hivyo wanaenda kwa Njuri Chenki? Kuna wapiga kura pale ambao ni wa makabila tofauti. Hata Wakisii wako pale, si ndio? Hata Wakikuyu wako pale, ambao ingekuwa ni makosa sana kwa jaji mzima kusema hawa watu wote hawa waende kwa Njuri Chenki ambayo ni ya kabila moja. Kwa hivyo tunataka Judicial Service Commission iseme kitu, na tunaomba kamati hii yetu ya JLAC pia ifikirie namna ambayo tutafanya malalamishi kirasmi kwa Judicial Service Commission kuhusu hukumu hii ambayo inapotosha watu wa Kenya na inahujumu mamlaka ya bunge la Senate. Asante Bwana Speaker.
Senator Joe Newton.
Thank you, Mr. Speaker, and I also rise to support this statement by the Senator for Meru, who doubles up as the Deputy Speaker of this particular House, Mr. Speaker. Mr. Speaker, this ruling by this particular judge was very disappointing. Why? Because when the County Assembly members of Meru decided that they wanted to impeach Governor Kawira once again, they knew very well that there was a Jurincheke in Meru. Kawira herself, the governor, also knew very well that there was a Jurincheke in Meru in place. And she chose to take the matter, or whoever took the matter to court knew very well that there was this particular council, Mr. Speaker. And so I think the judge was out of order because you cannot refer. Mr. Speaker, I can liken it to somebody who has gone to a chief, who knows there is a chief, but goes to a DO. Then the DO tells them, go back to the chief. Mr. Speaker, this particular judge abdicated his responsibility. Mr. Speaker, when Governor Kawira was brought here for the last time on impeachment charges, she actually used Jurincheke as her defense. And in that defense, Governor Kawira convinced this Senate that actually her impeachment had been engineered by MCAs through Jurincheke. So, Mr. Speaker, we cannot then, this judge could not then have, was actually again out of order to have referred the matter to Jurincheke, which Governor Kawira already had submitted before this honorable house that it was behind her impeachment last time. And so, Mr. Speaker, this is a judge, for lack of a better word, that is irresponsible, and a judge that abdicates his responsibility. And even without discussing his conduct here, a committee, the JSC should do something about this judge, and the jailer committee in this house, Mr. Speaker, should also pursue this matter, and if possible, see whether these...
Sorry, Senator Kongo Mugeni, what is your point of order?
Yeah, Mr. Speaker, I appreciate the magnanimity of the issue at hand. But, Mr. Speaker, we also have to be guided by our standing order, especially standing order number 1, which prohibits us from discussing the conduct of the judge. What we should be doing is to critique the content 101. Okay. What we should be doing, Mr. Speaker, sir, is to discuss the content of the ruling, but not to bring into discussion the personal character of a judge. That is prohibited by standing order number 101, which obligates us to bring a substantive motion with 3 days' notice. But it's permissible, Mr. Speaker, to discuss how it is inappropriate for that judge to issue a ruling that directs that matter to Jurincheke. That is within our realm. To critique the decision, but not the person who made the decision, Mr. Speaker.
Mr. Speaker, I think Senior Counsel Omogeni was either not listening to my submission or is directly malicious against me, Mr. Speaker, because I never discussed the conduct of the judge, Mr. Speaker. I discussed the ruling, and I said this judge abdicated his responsibility by referring a matter to a council of elders whom the governor knew existed but did not refer the matter to him. And Mr. Speaker, I also said, and I beseech my senior Senator Kongo Mugeni to be more keen next time. I also said that Governor Kawira used this actually in her defense. She submitted before this honorable house that Jurincheke was against her and is the one that had schemed her impeachment, Mr. Speaker. And so I said it was wrong to refer the matter, and I want to believe that Governor Kawira took it to court, refer her to a body that she believes is very hostile to her. And that is...
Honorable Senators, I can see the time that was allocated is over now. But let's last, but no, at least one more, two more. One from this end, Senator Mandago. No, I'm winding up these things so that we can move on to the other one.
Yeah, me also.
Thank you very much, Honorable Speaker. Honorable Speaker, first I rise in support of the decision of the judge, Honorable Speaker. And allow me to be the devil's advocate, Honorable Speaker, because the Alternative Dispute Resolution Act 2021, which I believe was passed by Parliament, Honorable Speaker, in Section 4, Honorable Speaker, the Act shall apply to civil disputes, including a dispute to which the national government, a county government, or a state organ is a party to. Honorable Speaker, it has been argued that Meru County is not a county for Merus only. But if you look at the definition of the people that are involved, Honorable Speaker, it says a community means a social unit or groups brought together by different types of affinities, such as culture, dialect, race, family, neighborhood, faith, business, age, and common interests. The common interest in this matter, Honorable Speaker, is the issue of governance of Meru, Honorable Speaker. And Honorable Speaker, if we look at Article 159, 2C, alternative forms of dispute resolution include reconciliation, mediation, arbitration, and a traditional dispute resolution mechanism shall be promoted subject to Clause 3. Honorable Speaker, if you follow all the way in that act, it says the parties may terminate the ADR mechanisms at any point of their choice. Honorable Speaker, therefore, the county government of Meru, the Honorable MCS, can at any point decide they are not interested in the alternative dispute resolution mechanism and they can go back to court. The reason we established ADRs was actually to try and reduce the workload, the unnecessary workload we have in our courts on matters that can be sorted out of court through a process that this Honorable House and Parliament legislated and passed the law, Honorable Speaker.
So
I don't want to be informed by Senator Wambua, a person who refused to become the Attorney General of this country. If you cannot be one, you cannot purport to even imagine, you can inform me, Honorable Speaker. Honorable Speaker, I therefore want to agree with the judge.
Senator Wambua. Yes, proceed.
I want to agree with the judge in Meru.
That's a minute, Senator Mandago.
Mr. Speaker, I am very surprised that a man of the character of a senator for Uasin Gishu, who is dealing with his own issues, whichever issue that he's dealing with, can stand on the floor of the Senate and connect me with a nomination for the office of the Attorney General. Mr. Speaker, I am not a lawyer. It is the same mistakes that they made when they made the first appointment of the AG by not consulting properly. Mr. Speaker, I want the senator for Uasin Gishu to withdraw any connection between the senator of Kitui and the office of the Attorney General before or then, unless then he wants us to follow that route, Mr. Speaker.
Under which is standing order, Senator Wambua? Because you are seasoned member. Yes. Senator Ambua knows exactly what he
Mr.
wants, and he
Speaker,
knows which is standing on.
Standing Order 105.
Yes.
A senator must be responsible for the facts that he alleges on the floor of the Senate.
Yes, Senator Mandago.
Honorable Speaker,
Raise yourself
I
to the
wish to
point of
withdraw
order.
and apologize, but clarify that as a principal advisor of party leader of Wiper, who is a lawyer, who was given the offer, Honorable Speaker, I withdraw and apologize. Thank you, Honorable Speaker.
Senator Kisang.
Thank you, Honorable Speaker. Honorable Speaker, I want to comment on two of the statements, one by Onyonga. Honorable Speaker, there are some entities, there are some companies that have been given licenses to explore minerals, but some have gone ahead and done mining, but they continue reporting that they are exploring. These are the companies that we need to call out so that they can apply for the next license to mine, so that our communities can get the right income, Honorable Speaker, from these particular companies when they export the minerals, Honorable Speaker. Honorable Speaker, my last comment is on your statement as the Deputy Speaker on Meru, Honorable Speaker. Honorable Speaker, for the last 2 years, you know your county, your people have not received adequate representation, especially in terms of delivery of services, Honorable Speaker, because of the county assembly and the governor have not had good working relationship, Honorable Speaker. That's why in under 2 years, we've had like 2 or 3, 4 impeachments, Honorable Speaker. So when I heard the church in Meru referring the matter to ADR, I thought this was court sent for these particular 2 warring groups, Honorable Speaker, to sit down and agree to work for the people of Meru. If they cannot sit down and work for the people of Meru, Honorable Speaker, I agree with what my colleagues, Gloria, that maybe it is time that we come up with a petition to dissolve this particular county. Let all the MCAs and the governor and the deputy governor go home so that basically you can go back for fresh elections. In Meru, we get a new governor, new deputy, and new MCAs, Honorable Speaker, so that things can work for the people of Meru. You can also decide to resign the Speaker and run for you can run for the position, Honorable Speaker. But I believe the fake fertilizer will not run for that particular issue, Honorable Speaker. Honorable Speaker, that is my take. During Cheke are respected. I don't know why they've run away from adjudicating, from reconciling these particular people. That's it.
Thank you, Senator Kisang. Senator Kongo Mogeni.
Thank you, Honorable Speaker.
Mogeni.
Hello? Yeah, Mr. Speaker, you know, we should not hit the judge so hard. You know, this constitution created an article called Article 159 on alternative forms of dispute resolution. And I want to inform senators here that even people who have committed murder have been referred to mediation, reconciliation, arbitration. So you cannot attack the ruling that was delivered by the judge because he was invoking an article that is in the Constitution. And you know, senators, you should read. Article 159 speaks of judicial authority, the power that is donated to the judge to give ruling and directions. But Speaker, I want to thank the injury check because I think injury check have seen the light. I read that they have applied to withdraw from the proceedings. And they want to allow that matter to run the full course. You know, and under Article 181, it's us, senators, who gave powers to our MCAs to initiate an impeachment. So now that the injury check, and I want to thank them because that's why we're here to deal with issues of impeachment. Now that injury check have seen the light, they have allowed this motion to run its full course. Let it be processed by the members of Meru County Assemblies. Let it come to the Senate. Can you see the Senate of Nyandarua is salivating. let it be processed, Mr. Speaker. It comes here, and we deal with justice. You know, Mr. Speaker, we must respond to the issues that are being raised by the MCAs and the residents of Meru. So let the judge, now that injury check have applied to allow that matter run its course, let the judge allow it to be processed, come to the Senate, and we do what we are supposed to do. Mr. Speaker, nobody should fear the senators of the Republic of Kenya, including Governor Kaweria. If I was her, I will not even bother to go to court. If she is clean, let the matter come here. We deal with it. If she is clean, she is acquitted. If on the other hand, she has committed issues that make it undesirable for her to continue holding that office, then again she should fall on the doors of justice. So there is nothing to fear. Both ways, there will be justice. If she is innocent, an acquittal. If she is guilty, she should go home. That's why we have accountability, Mr. Speaker, in our Constitution. Thank you, Mr. Speaker.
Senator Chute, you know I cannot see your request on my screen. I don't know if there is.
Thank you very much.
There's a constitutional matter that is raising.
Thank you very much.
I cannot see his request. And that's the last one, then we proceed with the other business.
Thank you very much. I wanted to add my voice on the issue of Meru. Honorable Speaker, my friend Senator Mandago quoted an article which he read halfway. And this is 159. If you look at 159C, alternative forms of dispute resolution, including reconciliation, mediation, arbitration, traditional dispute, resolution mechanism shall be promoted subject to clause 3. And clause 3, Honorable Speaker, says, traditional dispute resolution mechanism shall not be used in a way that A, contravenes the Bill of Rights, B, is repugnant to justice and morality, or results in outcomes that are repugnant to justice or morality, or C, is inconsistent with this Constitution or any other written law. Honorable Speaker, Article 181 is very clear. It tells us how to remove a governor from the office and the deputy governor also. Honorable Speaker, I'll give you an example of Marsabit. We don't have Njuruncheke in Marsabit. What will happen if the members of the National Assembly want to impeach the governor? Are they going to ask for Meru Njuruncheke to come and help us there? No, it is not possible. Again, Honorable Speaker, if the issue being raised by itself has some criminality issue, wastage of funds, resources, misappropriation of money, yes, it goes against Article 6. So, Honorable Speaker, I really thank the Njuruncheke for referring back that issue to the courts. And we are waiting for Governor Kawira Mwangaza here before the Senate. We are ready and waiting for her to come here. Honorable Speaker, finally, I think it is very important for us to look at the law. This Constitution, 2010, is one of the best constitutions that any person can have, especially in African countries. Let us not ignore this Constitution and follow traditional ways to solve some official issues. Thank you very much, Honorable Speaker.
Thank you, Honorable Senators. Now we proceed with the business of the day, and standing under 45.2, I wish to reorganize the business of the House this afternoon. So we move to standing on, we go to order number 21. Then after we execute that, we go to the normal system. So, clerk, read the order number 21.
Order number 21, the Land Amendment Bill, National Assembly Bills number 40 of 2022. Second reading.
Majority Leader.
Thank you, Mr. Speaker. Mr. Speaker, I beg to move that the Land Amendment Bill, National Assembly Bill number 40 of 2022, be now read a second time. Mr. Speaker, this is an extremely important matter, despite the fact that it's one of the shortest bills that I've ever introduced in this House. But it serves an interesting purpose, Mr. Speaker, where we are seeking, Mr. Speaker, to secure public land for public institutions and ensuring that after such is done, Mr. Speaker, we provide the legal mechanism for the titling of such land. As it is today, Mr. Speaker, many public institutions actually continue to lose land that has been set aside for them on account of vague provisions of the law on the titling process of such parcels of land. And therefore, Mr. Speaker, hence the Land Amendment Bill, National Assembly Bill number 40 of 2024, which was published in the Kenya Gazette Supplement number 165 of 2022 on the 28th day of October in the same year. This bill was considered and passed by the National Assembly, after which they referred it to us for consideration. And I've explained, Mr. Speaker, that the principal object of this bill is to amend Land Act number 6 of 2012 in order to provide where public land has been allocated to a public body or a public institution by the NLC for a public purpose, or where the land set aside by persons or even a land buying company for public purpose, the Register of Land under the Land Registration Act of 2012 will issue the certificate of title in the name of public body, public institution, or the relevant ministry, as the case may be. So, Mr. Speaker, the key word or operating principle in this bill is public. Public land, public institution, and for a public purpose, Mr. Speaker. Therefore, it is a sacred move, if I may call it so, Mr. Speaker, because we all know of public institutions that up to date continue to lose land on account of either poor titling or the lack actually of legislative intervention on our part, Mr. Speaker, to ensure that after a donation has been made, Mr. Speaker, or even an allocation or setting aside of a public piece of land, Mr. Speaker, to a public institution, it is titled in the name of that institution. Mr. Speaker, Kenyans' obsession with land is legendary. And therefore, Mr. Speaker, there is need actually to ensure that our public institutions have their land firmly secured by ensuring that the title is registered in their name every time that land has been set aside. You know for a fact, for example, Mr. Speaker, that in many of the urban spaces here in Nairobi, there were public pieces of land that were set aside either for playground or social amenities, Mr. Speaker, but today cannot be traced. In fact, 70 to 80%, my own honest estimation, I have no strong data to back that up, but just based on my common knowledge of this city, Mr. Speaker, that land today you cannot trace it to the public purpose for which it was meant or for which it was allocated to. For the simple reason, Mr. Speaker, that we didn't have this provision to ensure that we title those lands in the name of the public institution or entity, Mr. Speaker. And that provided ripe environment, Mr. Speaker, for marauding public land fraudsters, Mr. Speaker, to quickly change the provisions of, or the title, Mr. Speaker, of that particular land and own it, or even do developments that are otherwise not public or not meant for public good. We have many examples, Mr. Speaker. In the last Parliament, Mr. Speaker, and I think I have seen even a petition before this House, we had petitions from, say, Nairobi Water Services Company, where staff houses belonging to that institution, Mr. Speaker, a contractor showed up on site with a group of young men, as is normally the case, They demolished the houses in the dead of the no time, Mr. Speaker. They put up high-rise apartments. And years later, up to now, Mr. Speaker, because, and it's part of what we were discussing a few minutes ago, that sometimes our judges also choose to be mechanical. All they ask of that public institution is, where is the title? The council meeting that provided the setting aside of that parcel of land, Mr. Speaker, for public use. Many times, Mr. Speaker, in the absence of a title deed, public institutions have lost land to fraudsters, Mr. Speaker. And that is what we are seeking to address in this particular bill. As it is presently, Mr. Speaker, public land and land set aside for public purposes by land buying companies continue to be grabbed by private persons, primarily because there exist no certificates of title issued in respect of that land. And I've explained that particular bit. Therefore, this bill, Mr. Speaker, seeks to provide for the registration of public land. You know the issues around even our primary schools, Mr. Speaker, especially in areas where land is of high value. Urban towns like Nairobi here and many other cities, Mr. Speaker, public institutions actually continue to lose land on account of the lack of legal provision. Of legal certificates, Mr. Speaker, to these public institutions will be crucial towards curbing unauthorized land grabbing, illegal occupation. Occupation is a big issue, Mr. Speaker. You remember, I think late last year, or was it early this year, there was the issue around Mavoko and Athi River, where many of those public land, East African Portland Cement and NSSF, Mr. Speaker, they continue to fall victim to this kind of games, where certain portions of their land, they dedicate them and they know in future if they do developments, the people who live there will need public utilities like hospitals and schools, Mr. Speaker. The very parcel of land that they set aside for that purpose, Mr. Speaker, because it's not registered to any public institution, Mr. Speaker, that land has since been grabbed. And that dispute continues. I think even yesterday I saw something in the news on NSSF land. And you know, they have since become even more advanced to the point that they involve even the police, some of whom are supposed to provide, Mr. Speaker, security to that particular parcel of land. They are enticed, Mr. Speaker, and they are told that please help yourself out as well. And together they team up with fraudsters, and therefore public loses land. Furthermore, Mr. Speaker, when you establish a system where land certificates are issued to public institutions once the land is owned, we enhance the legitimacy in land transactions involving public land. Ultimately, the proposed bill will not only protect the integrity of public land, but also pave way for responsible utilization of these lands for the benefit of society as a whole. Reason being, Mr. Speaker, that land that has been registered, say, to a school, it will be impossible for somebody to cheekily register some quasi-public institution, as is normally the case. Normally people begin something that, like a church, or, Mr. Speaker, so many other institutions that from the look of it appear to be benefiting the public, but actually are used for private benefit, Mr. Speaker. Once you register this title in the name of a public institution, it becomes impossible, Mr. Speaker, for somebody to go ahead and use that particular land for any other purposes other than what it was meant to achieve, hence the importance of this bill. To the specifics, Madam Speaker, of this bill, Clause 1 is simply about the title of the bill, the Land Amendment Bill 2024. Clause 2, Mr. Speaker, provides for the amendment, the specific one. You are actually amending Section 2 of the Principal Act by inserting a new definition of registrar to have the meaning assigned to it under Section 2 of the Land Registration Act of 2021, a law that we passed here in 2021, Mr. Speaker. Clause 3 of the bill, Mr. Speaker, proposes to amend Section 12 of the Principal Act by inserting the following new subsection immediately after 280, subsection 12, which is now subsection 13, which reads that a public body or institution shall apply to the registrar for registration of public land allocated by the Commission in the prescribed form. Therefore, you provide the prescribed form for registering this public land, Mr. Speaker, in the name of that public institution either present or even for future use. Many institutions, Nairobi University here, Kenyatta University, you remember the dispute about their land and the new KU hospital, Mr. Speaker, and allegations and counter-allegations, Mr. Speaker, of who the intended beneficiaries of that particular land will be. Section 14, or the new clause 14, Mr. Speaker, provides that the registrar shall register the public land allocated to a public body or institution by the Commission. It places a mandate, Mr. Speaker, on the Commission, on the registrar, Mr. Speaker, to actually do that registration. Lastly is on clause 15, which is pursuant to section 58 and paragraph 7 of the third schedule to the Physical Land and Land Use Planning Act of 2019, the registrar shall register the land set aside by a person or land buying company for public purpose consequent upon proposed development specified. 16, Madam Speaker, will be upon the registration of land under subsection 14.15, the registrar will then issue the certificate title. In the case of an incorporated public entity, the certificate shall be in the name of that entity, if that entity, that public entity is already registered, Mr. Speaker. In the case of an incorporated public entity, the Cabinet Secretary of the National Treasury as a trustee. That's very important, Mr. Speaker, because in many developments, the setting aside of public land for future public use is normally futuristic, where citizens, out of their goodwill, actually dedicate a certain portion of the land and say, in future, we intend to develop this, either a university, a college, Mr. Speaker, a playground for young children. Mr. Speaker, it is important that this is registered. Mr. Speaker, I don't know if I am being overly creative. I have since seen a dispute where residents, Mr. Speaker, of public or private, Mr. Speaker, private developments have sued actually the developer, Mr. Speaker, on account of the fact that when they were purchasing the either apartment or the houses, Mr. Speaker, in the approved development plan, there was provision for public utility, like a playground, Mr. Speaker, or a hospital, or a nursery. Then, of course, as is often the case, Mr. Speaker, that developer changes their mind once the residents have moved in. And since the residents have no recourse in law, because ideally they don't own that piece of land, Mr. Speaker.
Sorry, Majority Leader, I'm lost. Are there two members who are moving the bill at the same time?
Why?
Because there is two voices. I'm hearing two voices. One from Senator Medu and another one from the Majority Leader. Who is moving the bill? Proceed is a Majority Leader.
You know, Nyandarua, Mr. Speaker, is famous for sending very intelligent old men. This is the first time they have sent a young man, Mr. Speaker. I didn't intend to say that, Mr. Speaker. But the young man will learn that you don't speak while the majority leader is moving a bill. Particularly, Mr. Speaker, a bill which he is supposed to second, and is coming in shortly. Mr. Speaker, the point I was making is that now, with the provisions of this new section 16, if you are a member of the public, you have bought into a private development, and that developer has set aside land, either to dupe you into buying into that development, or with the good intention of having that land set aside for actually your use, Mr. Speaker. This provision of the law can be cited to ensure that that private developer, Mr. Speaker, because this is not only to public institution, is actually registered, Mr. Speaker, for the intended good of that private development, Mr. Speaker. And since perhaps maybe there is no registered residents association, then you will have the CS for Treasury, Mr. Speaker, being a trustee, because that particular parcel of land will be set aside. I have since seen disputes, Mr. Speaker, where residents take up in arms and they say, wait a minute, when we were buying this development, we were assured that there will be a playground for our children. Why has the developer changed mind? But unfortunately, because of the absence of this law, Mr. Speaker, you find actually that those citizens have no proper recourse in law. This will now cease being the case after we pass this bill and it is enacted into law. In case of a county government, it will be in the name of the county government, Mr. Speaker, such that if that land is being set aside, say, for a facility, which the county government say a dispensary or something, it will be in the name of that county government. Mr. Speaker, sir, with these remarks, I beg to move and now request the very intelligent but sometimes distracted Senator for Nyandarua, Senator John Methu, to second.
Senator Methu.
Honorable Speaker, as I rise to second this particular motion, allow me to first make, with your permission, an observation that I have made on two of our very senior legislators in this House, the Senator for Tana River, Senator Danson Buya Mungatana, and the Senator for Kakamega, Senator Dr. Boni Halwale, who was a parliamentarian when I was a primary school kid. And Honorable Speaker, the observation that I've seen about the two legislators is that they take their legislative work very, very seriously. Rarely will you miss the face of Boni Halwale sitting from 2:30 to 6:30 every day, and it is the same case for the Senator for Tana River. I see the Senator for Kiambu a bit excited. He wants me to include him in that list. And anyway, because I am cut of the cloth of the truthful men, I'm holding back to including him in that particular list. So we are learning from the best. I entered my school, went to high school, went to university, and still found you here. You have not left, you are still in this house because you are taking your work very, very seriously. Honorable Speaker, as I rise to second this particular motion that has been brought by the leader of majority, Honorable Speaker, I'm being distracted by the Senator from Kisii, Senator Grulia, who is actually pushing that it is now time for the Senator for Kakamega to now go and serve the people of Kakamega in other positions, Honorable Speaker, as a governor. But I think that is up to him. That he will make that choice. He attempted sometime, but many other things happened. Honorable Speaker, I am seconding this particular motion.
The motion.
Thank you very much. Thank you very much for your guidance. You also that we are looking up to, having served in your since you're also serving your third term, Honorable Speaker, because if then my calculations are right, you started serving in 2013 and I was still a student. So you're in that category of the people that would want that you keep serving this nation. Honorable Speaker, the purpose and the intent for this particular bill, as has been elucidated by the leader of majority, Honorable Speaker, is to ensure that all our public land is registered in the name of the institutions upon which this public land has been granted, Honorable Speaker. And the cure and and passed by this House, Honorable Speaker, is that as the Chairman Committee on Lands, 60 or 70% of all the petitions and the statements that are sought by members of this particular Senate and even members of the public, Honorable Speaker, they always have a question on either grabbed land, public utility, or an intent. This morning, Honorable Speaker, you know that we are dealing with the issue of the Siani wetland in Nyamira County, Honorable Speaker, where some people have made an intention of grabbing that particular swamp, Honorable Speaker. So, Honorable Speaker, if a public utility has been given ownership documents to land, Honorable Speaker, it will bring cure to the perpetual grabbing of public land. Honorable Speaker, you know, the way public utilities are wired, the leadership of public utilities keep changing. Today, the head teacher of this primary school will be the head teacher of another primary school. The board of management of this hospital will not be there tomorrow. The governor of this county will not be the governor after his or her 2 terms, or if after 1 term, Honorable Speaker. So the leadership of facilities that hold public utilities, Honorable Speaker, keep changing, Honorable Speaker. And if then there are no proper documentation on the land that they own, it then breeds root to grabbing of this particular land, Honorable Speaker. It is the case for a primary school that we are dealing with a petition, Honorable Speaker, from Nyandarua, Magomano Primary School, which initially, if you look at the first mutation of the maps that we have, Honorable Speaker, the primary school has 28 acres. But somebody else has produced documents, ownership documents, and has left the primary school with 14 acres. And we are almost deciding to faith, Honorable Speaker, because the primary school does not have documents. The private person has the documents, Honorable Speaker. So it is upon this that after the National Land Commission has granted you land, Honorable Speaker, then the second process and the second matter that's processing that particular, the documentation of that particular utility. There's something else that has been the intent of this particular bill. You see, and I am sure the Senator for Kiambu will be very interested in this particular conversation. The dispute that you see in their Tatu City development structure is that of the 15,000 acres parcel of land, there has been an intention to have 406 of that particular land, I think other utilities in that particular development. But now, as the development keeps growing, as the developer keeps growing, keeps developing, I think for the initial 5,000 acres, there was 406 acres that was supposed to go for private use, for public use, Honorable Speaker. But over time, as that value of that land gets growing, the developer keeps reducing that land.
Without registration. It was not registered to anybody. Honorable Speaker, after some years, someone will come and claim that land and register that land and sell it or develop some units of houses. Honorable Speaker, what this amendment bill, bill number 2024, is trying to do is once you register, once you subdivide a particular land, that land should be registered. And what must be done first, Honorable Speaker, is to register that public utility land first. And the issue of registering it will make sure that that land will be preserved for the purpose that was intended for. Honorable Speaker, if you look at mosques, for example, a landowner can allocate land, subdivide land for his children or other relatives. And out of that, he will demarcate some part of that land for mosque use. And on many occasions, Honorable Speaker, after that muzee has gone, children will come and claim even that land. If that land is registered as mosque or as madrasa or as any utility, public utility space, I think the registration will deter anybody who will come and claim that land. Honorable Speaker, there is something that is very, very important in this bill, and this one is, look at number 15, pass on to section 58, paragraph 7 of the third schedule to the Physical Land Use Planning Act 2019. The registrar shall register land set aside by persons or a land buying company for public purpose consequent upon proposed development. Honorable Speaker, and emphasis should be put in place that before anything happens, before subdivision is approved, that land should be kept aside, should be registered in the name of particular organization. If you look at how it was meant to be done, you go to number 16. Upon registration of land under subsection 14 and 15, the registrar shall issue a certificate of title. Very important, Honorable Speaker. In the case of an incorporated public entity, the certificate of title shall be issued in the name of the entity. These are mosques, churches, schools, and any other institution that has been given this land. And B says, in the case of an incorporated public entity, the Cabinet Secretary to the National Treasury shall, as trustee, register this company under that trustee. Honorable Speaker, this is very important. But what we need to do is this. Honorable Speaker, normally what happens in this country, it can be registered under National Treasury as a trustee. But then what we need to add, another amendment, if it can be done, is that land is not for sale, for resale. It is meant for a particular purpose. If it is meant for a hospital, it should remain for a hospital. If it is meant for school, for a school, for a school. That it must remain for the purpose that it was kept aside for. In the case of C, a county government should keep that land, register under the county government as a trustee. Similarly, Honorable Speaker, the issue of registering only is not that important. What is important, Honorable Speaker, is for even if, for example, the current governor or any governor leaves that office, another governor can come in and make excuses to register that land under other purposes and again reallocate it or subdivide it and sell it to other people. Honorable Speaker, a very good example I'll give you today. In Marsabit, there were land that were allocated to the government, and government houses were there, built in 1960s, early 1960s. Those land today, or the houses, were subdivided and allocated to individuals in that county. I have a statement in that regard, and I'm waiting for correspondence.